Hi, and welcome back. Attorney Steve Vondran here. We're talking about Malibu Media and an abuse of process counterclaim. So this is a really interesting case here. This is general legal information only and not legal advice. So this video, we're talking about abuse of process. We talked about it in other videos that we have out there. But this is one that's playing out right now, so I thought I would just show it to you. This is a case we're tracking here. This is a case of Malibu Media Llc versus Mcmanus. This is a New Jersey case, and I love this. William J. Martini presiding. If I was a judge, that would be my name for sure. Martini, I love that. Anyway, so, but here we have it. Let's just walk through it real quick here. You have your standard. I call it standard because they have filed, both Malibu Media and Strike 3 Holdings, two of the big torrent lawsuit filers. They have filed tons and tons of these cases. So here you can see it's in the District of New Jersey. You got another John Doe case. We've talked about John Doe in other videos, what that means. But it's a complaint for property rights infringement, basically copyright infringement, as you can see here. And they call defendant a persistent online infringer of plaintiff's copyrights. So this is the illegal file sharing the movies online, downloading. And they had defendant's IP address, so they filed the complaint, as we've talked about in many of our videos. I'm not going to go into details on that. What I want to go into was basically the answer to the complaint. If we come down here, there was some amendments and things in here, but come down to the answer to the complaint, and you'll see how the defendant responded in this case. They filed an answer, separate defenses, counterclaim. So let's go down to counterclaim. Basically, the defendant said, you know what, we didn't do this. We're going to fight it. And this is what we call the litigation track in torrent defense, okay? So if you come on down, you can pause all that if you want to read it, but come on down, you can see they filed a counterclaim. They put their separate defenses. Here was failure to state a claim upon which relief can be granted. And you have some interesting arguments in there. What else? We come down here. I'm not going to look at all the defenses right now. But if you keep going down, counterclaim, there it is, abuse of process. Defendants, counterclaimants incorporates by reference that plaintiff made knowing misrepresentations in the second amended complaint. Plaintiff pleaded claims for copyright infringement despite knowing that an IP address alone is insufficient to identify an infringer. Plaintiff pleaded claims for statutory remedies despite knowing that those claims were likely unavailable. So they filed abuse of process saying this is no way to use the court system. There's some more argument in there. I'm going to let you look at that if you want to read it, but essentially plaintiff intentionally failed to disclose and concealed pertinent and material information regarding plaintiff's knowledge of the falsity of certain events and the ulterior illegitimate purposes for which the complaints were employed. So basically, you can read that if you want, if that's of interest to you. But what I found interesting is, so they filed a counterclaim for abuse of process. And then it looks to me, by looking at the docket, that the case went, that was docket file number 46 over here. It looks like it went on to further a status conference, settlement conference. So they had gone through some of the steps, and eventually, apparently, I guess they couldn't get the case settled, but they came down, and finally, it looks like Malibu Media just didn't want any piece of this anymore. So here at docket number 56, here we have the plaintiff, Malibu Media, motion for voluntary dismissal with prejudice of not only plaintiff's claims, their own claims, but also to dismiss defendant's counterclaims. So this was really an interesting turn of events. So here you have the plaintiff who picked the fight in the first place. Now, after an extended battle, they want to get out. They want to cut the bait and run. So here you have it. And so that's really interesting. So they filed that. There's a little mini brief, looks like, that goes with that. So you can come in here, take a look at the mini brief. But they're basically telling the court, please allow us to dismiss this case voluntarily with prejudice and to dismiss theirs. In other words, judge, nothing further to see here. And so they base it on this sort of what we call the business defense. It's like not sound business to continue prosecuting my claim. So they say here, after further investigation and representations made by defendants regarding liability, i.e. probably that they disputed it, and upon additional investigation by plaintiff has elected not to pursue its claim against defendants, as the present evidence does not support the time and expense that it would be incurred in an attempt to bear out defendants' infringer status as a direct or contributory infringer, as it appears that the defendants are sophisticated IT professionals with the knowledge to hide infringing activity. So they're basically telling the court, look, the defendant is really sophisticated IT professional. They can really hide evidence really easy, and we could end up with nothing because they're really good at hiding evidence. And so we want you to dismiss not only our claim, but also their claim. So I think this is going to be a really, as they say here, to conserve judicial resources. Now we have Malibu Media, if you can believe it, talking about wanting to conserve judicial resources and prevent unnecessary expense for the parties. So this is really, I actually got a chuckle out of that. So so Malibu Media, who's filed hundreds and hundreds, if not thousands of lawsuits, is now concerned about conserving judicial resources, folks. There you have it. You can't make this stuff up. So at any rate, if you go down, I'm not going to go into all this. Here's their legal argument. It's basically, let's go down here. It's basically them saying, Judge, it's a business decision. Here, let's take it from here. As plaintiff seeks to dismiss this matter, plaintiff will not suffer any prejudice or legal harm to the defendant. Okay, well, they were dragged into court. Plaintiff has been diligent in prosecuting the case, and the defendant has not filed a motion for summary judgment. So what they're really just saying is, there's cases, as they say here, allowing for dismissal when it's, when it concerns a cost-benefit analysis, plaintiff's cost-benefit analysis of pursuing it made it not worthy of pursuing. So they're trying to convince the court that, look, we're just making a sound business decision. Plaintiff's decision right here is a business decision based on the examination of the information provided by the defendants. So this is going to be really interesting to see if this one works out. My gut suspicion is that they will probably dismiss the plaintiff's case, but I don't see why they would be dismissing the abusive process claim unless there really is just no evidence at all. So that's going to be something for us to find out. But as you can see here, final docket entry I'm going to show you here, just so you can see how these play out in real life in federal court. Okay, they filed the defendant filed a brief in opposition to the motion. So you come to docket 59. And here they are saying, Judge, not so fast. Don't let the worm off the hook. Don't let the worm off the hook. So they're saying, Judge, here's their essential argument here. Judge, plaintiff's complaint and defendant's counterclaim should not be dismissed because defendant's abusive process counterclaim is separate and distinct from plaintiff's complaint, and because defendants have suffered harm and would be prejudiced by dismissal of any claims. So this is really interesting. So we're going to see this one play out. There'll probably be a ruling on this pretty soon, but pretty funny. We'll see what happens. And this is important to understand in these copyright infringement cases, not just your torrent cases, but in copyright infringement cases where you're dealing with copyright trolls, porn trolls, software trolls, photo trolls, whatever you're dealing with. You may need, if there's no facts backing them up and you're the defendant, counterclaims for declaratory judgment or abusive process. We see them being filed, and here's one that we're going to be watching this to see how the court rules on this, okay? So if you want to stay updated and get legal news instead of political news, who wants that political garbage that brings everybody down? This is some news you can use. And if you need help with a torrent case, internet law, social media, copyright, that kind of thing, you know where to find us on the web at attorneysteve.com. That's attorneysteve.com. attorneysteve.com, the first name in legal services. We hope you enjoyed this video. If you did, give us some support and some love. Punch that like button. It's not going to kill you. Punch that like button. Leave any comments that you might have. Keep them friendly, please. And if you like our video channel, please subscribe. We're over 12,000. We're pushing for 15,000 this year. So we really do appreciate your support and your followership. Okay? Have a great day, everybody. Attorney Steve, we'll talk again.